We're back on the record and calling People versus Wolf, file 23-6613 FH. We're here for docket call and bond violation hearing. Do you know how we're proceeding, Mr. Gilbert?
Well, in regards to the bond violation hearing, I did go through the all the different missed tests and how I keep saying that there were no missed tests, missed calls, and the times that he did test positive. It appears that there was about 5 instances that he tested positive for alcohol. The other ones are THC, but he does have a card. So he would like to admit to the missed calls and that he had alcohol and admit to a positive alcohol.
All right, Mr. Wolf, as best you can you raise your right hand for me? Yes. You swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
I do. You put your hands down. Mr. Wolf, has anybody promised you anything in exchange for your plea to contempt?
Absolutely not, Your Honor.
Has anybody threatened you?
No, sir.
Is it your own free choice?
Yes, sir.
You understand you have the right to have a hearing, and if I where the evidence would need to be proven beyond a reasonable doubt, and Mr. Gilbert would assist you at that hearing?
Yes, Your Honor.
You understand that if I find you in contempt, I can jail you for 93 days, fine you for $7,500 or both. I can also revoke your bond if you're not complying with its terms. Do you understand that?
Yes, Your Honor.
Or how do you wish to plead to being in contempt court?
Guilty, Your Honor.
So as part of your bond, are you required to call into the bond line daily
Yes, Your Honor.
and not to use or possess alcohol or controlled substances?
Yes,
without
yes.
restriction?
Absolutely, Your Honor.
Did you miss a few calls in October, or I'm sorry, in August and September?
Yes, I did, Your Honor.
And did you
I just forgot. Yes.
Did you during the summer and fall test positive for more than one occasion for using alcohol?
Yes, Your Honor, I did.
Okay, and were you drinking?
No, Your Honor, I wasn't. I haven't drank. I'm a recovering alcoholic. I haven't had a drink in 3 years. It would ruin my life.
How'd you test positive for alcohol?
The only alcohol that I have any contact with is for my wounds, to clean my wounds, and maybe I don't drink, Your Honor. If I drank, it would ruin my life. But I'll admit they're there, so I did them. It's there, but I did not drink a drop.
All right, well, I'm going to find that your plea is knowingly, understandingly, and voluntarily made. There is sufficient reason to find that you're in contempt of court, so I do so find. Mr. Gilbert, you want us to decide sanction right now?
If we could, Your Honor.
Go ahead.
I'd ask that he has been incarcerated now for approximately, I believe it's been 7 days since he was taken into custody. It does appear that from what he says to me, that I do think he can cure the alcohol issue if it's getting into his system via cleaning wounds or that type thing. I know he has a number of health issues. And I would ask the court to consider time served and reinstating his bond.
Well, thank you, Mr. Wolf. You don't have to make a statement. It is allowed. Is there anything you want to say or not?
Yes, Your Honor. My children are more important to me than anything in the world. I wouldn't do anything. If I miss some calls, I'm sorry. But between my mom dying and these surgeries, I've just spent a lot of my mind. I know there's a couple of times where I was in the hospital from 5:30 till 5:30, you know. But I called the courthouse both times and told them the alcohol, I will figure it out and it will never happen again. I don't know what I can't drink. If I drank a drop, it would be the end of my life. But whatever's happening, it will never happen again.
Thank you. Ms. Goodrich, people's recommendation.
Your Honor, as explained last time in court, the violations go back to district court. It was the concern that is not taking the bond condition seriously.
Yeah, I mean, I agree, Mr. Wolf, and I don't believe for a second what you told me about not drinking. You know, rubbing alcohol for wounds does not result in an ethyl alcohol or ETG test. You're not rubbing vodka or wounds going through your mouth and into your body.
Yes, Your
and
Honor.
you're lying to me about it. And it's going to be 93 days in jail. You are not complying with bond whatsoever. And let's see, how many days you've been in now?
7, 8.
Credit for 8 days. Bond continues to be revoked. Once you serve the contempt sentence, then I'll listen to whether we should reinstate your bond. But you're going to serve that sentence. And you and I both know you were drinking, so
Yes,
stop lying to me.
Okay. Yes, Your Honor.
All right, let's schedule this for a docket call then on maybe December 19th at 2:50. All right, now we've got People versus Zachary Coonrod. It is file 2020-6040FH. We are providing public access both in the courtroom and also online. Counsel, you want to state your appearances, please?
Melissa Goodrich, Lynn County Prosecutor.
Good afternoon, Your Honor. James Gilbert acting on behalf of Mr. Coonrod.
All right, and we also have Agent LaFlesh from the Department of Corrections who's present. And we're here for, well, we've got two things. One, we've got sentencing, but we also have hearing on contempt for Mr. Coonrod's failing to appear for a sentencing hearing on October 24th. Do you know how we're proceeding on that, Mr. Gilbert?
Yes, Your Honor. I did talk to my client about this, and he is going to admit that he was supposed to come. We made arrangements for him to turn himself in after he got out of the hospital, and he did not do that.
All right, Mr. Coonrod, you want to raise your right hand for me, sir? Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Please put your hand down. Do you understand you've got the right to have a hearing where your contempt would need to be proven beyond a reasonable doubt, and the right to Mr. Gilbert's assistance at that hearing?
I do.
If I find you to be in contempt, I could jail you for up to 93 days and or fine you up to $7,500. Do you understand that?
I do.
Has anybody promised you anything in exchange for your plea of contempt? Has anybody threatened you?
No.
Is doing so your own free choice?
Yes.
Knowing all this, how do you wish to plead to the allegation in your contempt court? So, did you become aware that you had missed a sentencing date in this case?
I did.
Did you become aware that there was a warrant for your arrest for that?
I did.
And did Mr. Gilbert make arrangements for you to turn yourself in on that warrant?
He did.
Did you fail to do so?
I did. I got the date wrong, Your Honor.
Well, what's that mean?
I thought the date was Friday.
Well, here's the deal, Mr. Coonrod. People can't be accidentally in contempt of court. So I need to tell you what you knowingly did that would violate any of my orders or your obligation to be here. What do you want to tell me about that?
Just that I mean, I definitely apologize. I didn't that morning the day prior, I had come down with the flu. The next day, same thing. I was still sick. Went to the emergency room. Well, went to my doctor's first, and they had transported me to the emergency room because I did go down in their office. In talking to Mr. Gilbert, I had thought he had said to make sure I turn myself in by Friday, which I would have been here by like 1, 2 o'clock, but I did get the date wrong. So
Okay. Did you come to be in custody because you were arrested?
I did.
Where were you when you were arrested?
On my way to the bakery.
All right, Mr. Gilbert, you believe that's sufficient factual basis?
I do, Your Honor.
Yes.
All right, well, Mr. Coonrod, I find that your plea is knowingly, understandingly, and voluntarily made. I do find that there's a sufficient basis to find you in contempt, and I do so order. As I've expressed before, I have some real skepticism about your non-appearance at the hearing. And certainly after you didn't appear and you knew there was a warrant, you didn't turn yourself in despite your attorneys urging you to do so. You had to be arrested by law enforcement on your way to a bakery. I think that is sufficient to show that there was a willful evasion of the court's process or of this case. So I do find you in contempt. So that leaves us now with sentencing on the contempt and the underlying case. And Mr. Gilbert, have you had a chance to review the report and recommendations with your client?
Yes, we did go through the report, and there are no additions or corrections.
All right, the advisory guidelines are scored at 0 to 17 months. Any scoring challenges?
No scoring challenges.
So there was no objection filed to the restitution amendment.
That is correct.
So, okay. All right, so anything you wish to say on behalf of your client?
Your Honor, I just asked that the court follow our plea agreement of no upfront jail and allow Mr. Coonrod to get going on making restitution payments to make the victim in this case whole. Thank you.
All right, thank you. Mr. Coonrod, you don't have to make a statement, but it is allowed. Is there anything you want to say or no? Ms. Goodrich, any recommendations from the people?
Your Honor, if the court would allow, I believe that Mr. Babbitt would like to speak.
Okay. All right, good afternoon, Mr. Babbitt. Been a long time coming. Go ahead and tell me anything that you want.
Yes, thank you, Your Honor. It has been a long time, but you've shown incredible patience, and the prosecutor has shown incredible diligence and perseverance, as did the police in Mackinac City, and they've worked on this for over 3 years now. It's been devastating to my family. I'm not sure if Mr. Coonrod thought we were a lot wealthier than we were, but the money we had, he stole. I'm coming up on 70 years old. My wife is 65. She's not in good health. And neither of us have any hope of being able to retire because Mr. Coonrod stole all of our life savings, basically. The restitution, the amount that we were able to prove and was confirmed through a forensic accountant was $590,000. That's the tip of the iceberg of what damage he did, financial damage he did to my family. That was money that he simply transferred from our bank accounts to his bank accounts, or money that he diverted that never hit our bank account. That's the 590. What's not included in that amount are all of the expenses and other costs to my family. Things like revenues that were never acknowledged, that were just diverted to his personal use. Things like, because all of the cash had been sucked out of these 2 hotels, we got behind on taxes. We were always behind on taxes. The state of Michigan is just oppressive in their pursuit of me and my family, threatening liens, threatening bankruptcy. Right now, right this month and every month for the foreseeable future, we will be paying the Department of Treasury and the IRS $4,000 plus every month for back taxes, penalties, and interest on those taxes. And the reason they weren't paid was because Zachary Coonrod stole the money. We would have had ample money to pay those at the time. That's not in that 590. Those expenses are not in that 590. Probably the biggest economic impact on the family was we basically were forced to sell the 2 hotels we owned. And at least in respect to one of the 2 hotels, because we didn't think it was making any money, and it didn't look like it was making any money because Zachary Coonrod was stealing it all, the profits, we took $1 million loss on that. The difference between what I paid for the hotel and what I sold the hotel was $1 million. You know, that was my family's future. That was, I'm coming up on 70 years old. We planned on buying those hotels, running them for 20 years, letting them appreciate in value, keep the loans paid through the proceeds, through the profits of the company. And that didn't happen. It didn't happen. I mean, there was no appreciation because it didn't look like they were profitable. The truth is they were profitable. Both properties were quite profitable and should have been sold for an awful lot more than we were able to. So that's one of those hidden damages that just doesn't show up on paper because you can't really quantify it. Everybody's been generous in asking me about how I feel about sentencing, and you can imagine I'm torn. You know, on one hand, because of what he's done to my family, the impact. My wife and I have worked since we were 16 years old. We put ourselves through college. Both of us have either been in school or working full-time since we were 16. And here we are at a time in our life where we should be thinking of retiring. We're not. We can't. My son, who just graduated from college, bless his heart, you know, he did it by working full-time through college, by taking loans, things that he should, you know, I'm not opposed to people working hard, I'm all for it, but he shouldn't have had to work that hard. And the reason he had to is because we had no money to help him. So when you come to sentencing, you know, I hope, you know, the baser side of me says, throw him in prison, let him rot there until, you know, for as long as it took my wife and I to make that money. Well, that's ridiculous. I'm saying, you know, this is the baser side of my emotions that are coming through. On the other hand, the pecuniary side says, get him out there, get him working, have him start paying me back. Now, I don't know how him paying me my money back is punishment. It's my money. It was my money he stole. And somehow having him pay me back a pittance, a fraction of what he stole, how that's punishment, it just doesn't feel like it to me. But I think that's what we would like, is him to start paying something, and on a regular basis. And I think, and I don't know if these are things that you do as conditions of sentencing, but this guy can't get near a gambling casino. This is where most of the money appears to have gone. He gambled it away. The worst thing in the world. If he bought marketable securities and real estate, there might have been something for him to reach to pay this. There isn't. He gambled. I mean, a more worthless way of spending money, I can't imagine. So I guess we want him to go to work and start paying us something. And I'm saddened. I mean, I've had over 2,000 employees in my life in the various businesses that I've owned. I can count on 3 fingers the number cheated me, and none of them compare to what's happened here. This is perhaps one of the largest single embezzlement cases in the history of the state of Michigan, as one individual stealing from another individual. I can't find any bigger. This is huge. And I don't think we can minimize that, and the cost to society. The number of people that are watching these proceedings and saying, you know, is he going to get away with it? Paying me back a little bit of my money doesn't feel like it to me, but thank God that's why we have disinterested judges, and good prosecutors and police, and I don't have to make that decision. But I appreciate you giving me this chance. It's cathartic, and my family thanks you. Best of luck.
Okay, thank you, sir. Let's go to the recommendations from the people.
Yes, Your Honor, we're here because for approximately 3 years between 2015 and 2018, Zachary Coonrod had stole over $500,000 from his employer. The unique thing about this case is during that time, the victim's wife was terribly burned, and on her way to the hospital, he had called Zachary Coonrod asking him to have his back so that he could focus on taking care of his wife, which would end up taking months due to the severity of her injuries. Instead of having his back, Zachary Coonrod stole the shirt off Rick Babbitt's back. After Coonrod entered a plea admitting to his actions, he did not make any attempts between that plea and now sentencing towards any payments of restitution that I'm aware of. He failed to appear at 2 sentencing hearings. And when he was arrested, it was my understanding that that day he was scheduled to sign a lease and had cash in his pocket. The defendant is 41 years old. He does not have any prior criminal history. He's employed at the bakery with an 11th grade education. He was given a reduction on the felony, giving consideration to his age and the lack of criminal history, but now we're here at sentencing. As the court is aware, there's 3 goals at sentencing: punishment, deterrence, and rehabilitation. This is a difficult case as a prosecutor because how do you make the victim whole? If the judge orders, if you order jail or prison, during any period of incarceration, Zachary Coonrod will be unable to make any payments toward the restitution. And if there is incarceration, what is the right amount? Is it a year? Is it 2 years? Rick Babbitt and his wife will suffer the consequences of Coonrod's actions way beyond any incarceration period. Like I said, unable to be made whole in this action and knowing that they'll have to make peace with that. If the court orders probation and he doesn't receive any jail or prison, did the goals of punishment and deterrence, were they achieved? How much payments will Zachary Coonrod make? How difficult will he make it for the court? And how will rehabilitation go? In the PSI, I was disappointed to see that he still fails to take any responsibility for his action. He blames others and tries to play the victim himself. The only accountability in this case was the plea that he took. We have a no immediate jail agreement, sentencing agreement. We did that so that he could start making restitution payments in hopes that he would start taking this case seriously, take responsibility so that we could all move forward, but especially the victim could start receiving something over nothing. The PSI's recommendation is 12 months jail and 3 years of probation. I would ask the court to consider that the defendant violated his bond after his plea by failing to appear to those sentencings without really providing any medical documentation that there was an medical emergency or necessity for going on those days or not turning himself in thereafter. The guideline range is 0 to 17. The sentencing guidelines do not take into consideration the multiple methods and number of transactions, as Mr. Babbitt said, the number of decisions that were made that Coonrod had used to steal from him. The Mackinac City Police Department did a great job tracing transactions. Zachary Coonrod was writing checks to himself and cashing them. At first, he would cash a portion and deposit a portion, but by the end, he was just getting careless and directly depositing the entire amount of the checks that he had written to himself into his account, which made it even easier to trace. He also was using a credit card machine to refund his personal credit cards. That was Mr. Babbitt's credit card machine, and then he would use his Zachary Coonrod's personal credit cards to put refunds on them. And lastly, he was as bold enough to purchase his own credit card machine. And then as customers of the hotel would come in, he would swipe their cards on his credit card machine so that he would receive all the profit. This took a lot of thought and planning and multiple decisions to do the wrong thing. The sentencing guidelines do not take in consideration the length of time that he was stealing from the victim. And as Mr. Babbitt said, we really never know, as often happens in these cases, how much was stolen. The sentencing guideline OB 16 stops at $20,000 in loss, and this was theft of over $500,000. Coonrod's bank accounts show that he, during this time, enjoyed a luxurious lifestyle, travel, numerous visits to the casino. As a result, as Mr. Babbitt said, he sold a hotel for not what it was worth, not knowing that those earnings were not there. And living with the traumatic reality, I think most of all in working with him, is that he was betrayed so deeply by someone he trusted so much during a difficult time that his family was going through. I'd ask the court to order restitution as submitted on September 11th of 2023 to William Babbitt in the amount of $590,321 and the Sheboygan Prosecutor's Office in the amount of $3,382.50 as submitted by our victim advocate. Thank you.
What's the precise restitution claim for Mr. Babbitt again?
Your Honor, I do have the printout here. I can approach it with sense of defense.
Mr. Coonrod, you're here having pled no contest to embezzlement over $20,000, a 10-year felony on the D grid with an advisory guidelines range of 0 to 17 months. A sentence agreement for no upfront jail that no longer binds the court or the prosecutor because of your post-plea misconduct that we established here today by not coming to court, not turning yourself in. That's entirely consistent with your behavior throughout this case that's lasted more than 3 years. I don't know what it is about you, Mr. Coonrod, but I do not understand. You seem to be constitutionally unable to take responsibility for anything that you do. You have avoided and delayed in this case several times. You have not cooperated with things that your attorney needed to help you out. You have, even after entering a plea, not lifted a finger to try to restore anything that you took from this victim. This was, as the prosecutor explains, this is a significant embezzlement case, not just the dollar amount, which is extensive, but also the effect on Mr. Babbitt and his family, the length of time involved from 2015 to 2019 in the offense states, the various types of ways that you devised to steal from Mr. Babbitt, and the ways that you frittered it away. All of those things are egregious, egregious conduct. The amounts at issue here, you know, you're originally charged with embezzlement over $100,000. That guidelines range is 21 to 35 months in prison. Your advisory guidelines range now is 0 to 17. Prosecutors write also that, you know, that range doesn't adequately take into account the amount at issue here. We can only give points up to $20,000. It doesn't take into account the length of time, the amount of the embezzlement, and the effect that you have had in destroying the financial security and the future hopes and dreams of one of our small business owners. They have to trust their employees. They can't run these businesses 24/7. I mean, they work more hours than people realize. But, you know, as a private practice attorney, I have represented various business owners, and I've never owned one of those type businesses myself, but in advising those clients, they put in blood, sweat, and tears and more hours than the public really realizes or appreciates. But they can't be there all the time. So they have to hire people, they have to trust them, and they do. And they usually, as Mr. Babbitt said, they make good choices about that. And he's had lots of employees over the years and had good experiences with hundreds of them, it sounds like. And then when you get one that comes in and does this, they can just absolutely destroy somebody. And that's what you've done. You've destroyed somebody. Based on your complete lack of cooperation with really anything we've ever asked you to do, even when you're presumed innocent and we're just asking you to meet with your lawyer and you're not doing those things. My confidence level in you paying restitution is about 0. In your willingness to do so, your level of compliance with my orders, also my confidence in your ability to. Right now you're working for what, $10 an hour? The probation officer calculated even if we took 50% of your paycheck, which wouldn't happen because of course, even on restitution, you're allowed to pay, you know, we don't have debtors prisons. We don't impoverish people for restitution. You'd be allowed to support yourself. So we can't take half your paycheck. But even if we could, it would take you 70 years. Hey, Mr. Babbitt. So I wish we could make restitution. Mr. Babbitt's right. Restitution is not punishment. Restitution is just making a victim whole. But we can't fabricate money. I'm not the Federal Reserve. We can't print that. We can't print it. So there's no way in this case. This is the sad reality. There's no way Mr. Babbitt's going to be made whole in this case. It's not going to happen. I wish it could, but that's just not going to happen. So that's not on our menu of options. When I consider all of these factors, I agree with the prosecuting attorney that the advisory guidelines don't take that into account. Also, that the sentence agreement is no longer binding given the post-plea misconduct. And Mr. Coonrod, I am going to commit you to the Michigan Department of Corrections for a term of not less than 2 years, no more than 10 years in prison. And you give me credit for what day did you come into custody? Well, what day did you come into custody on the warrant?
The 29th.
29th. So how many days are there? 14, 16 plus the 2. I'll give you credit for 18 days that you've previously served. There's restitution to Mr. Babbitt in the amount of $590,300.21. Restitution to the prosecutor's office for expert witness fees, the amount of $3,382.50. Crime victims assessment of $130 and state cost of $68. You have to comply with DNA testing and pay a $60 fee. That sentence is outside the advisory guidelines range. I believe that what I've announced is a proportionate sentence when you take into account the time involved, the methods involved, and the amount involved. I think it's more proportionate than the advisory guidelines offer us. Mr. Coonrod, if you wish to appeal, you have to file an application to the Court of Appeals. If you want me to appoint an attorney for you, I would. You'd have to ask me within 42 days. We're going to hand you some of your appeal paperwork right now and ask you to initial one set for us, the other ones for you to fill out if you wish to take an appeal. Also.
Judge, did you say something?